Good morning, good afternoon, good evening, everybody. My name is Sergio Sinovas from the CNMC. On behalf of the Merger Working Group, ICM Merger Working Group co-chairs Mauritius, France, Canada, and Spain, we welcome you to this webinar on merger analysis and FDI screening as one of our annual projects for this ICN year. With further delay, I will give the floor to Rachel Brandenburger, who is going to be the moderator of this interesting webinar. Thank you, Rachel, and all the speakers.
Thank you so much, Sergio. So I'm Rachel Brandenburger. I've got the great pleasure of moderating today's panel. I have a background in private practice and as an advisor to government, and I have worked on both sides of the Atlantic, and I'm speaking today in my capacity as a visiting research fellow at Oxford University. So it's a great pleasure to be moderating today's webinar on the interface between merger analysis and FDI, foreign direct investment screening. It's great to have so many participants joining this webinar. I'm not surprised we have a lot of participants. This is an important and very topical matter. I think it's also very much a landmark for the ICN as a webinar. I mean, as I'm sure many people know, ICN was founded 25 years ago to focus on only competition and to have participants of only competition authorities. Today's combination of talking about competition law and the FDI regimes shows how our world is changing, how the geopolitical challenges that we're facing are impacting on what agencies around the world are needing to focus on. So this interface between national security issues and competition issues is ever more important and topical. So against that background, I'm going to ask each of the participants to introduce themselves in a minute. We're planning a very interactive session this morning with questions and answers that we've discussed amongst the panel, no formal PowerPoint presentations. And then towards the end of the session, if there's time, we'll open up the webinar for questions from the audience. So please think about your questions as we go and put them in the Q&A if you have any questions. Last introductory word from me on behalf of all of the panelists to make the usual disclaimer that they are speaking in their personal capacities and not on behalf of the institutions or organizations that they work for. So with that, let me hand over, and in terms of how my screen is looking, no particular magic to this order. Let me start with Santiago.
Thank you very much, Rachel. So I am Santiago Conde. I would like to just point out that I feel very much at home during this panel because in the past I served as case handler for the CNMC, especially under the direction of Sergio Sinovas, who is, I'm sure, watching. So I was serving as case handler in the CNMC, and now I'm serving as assistant deputy director for the FDI screening unit in the Ministry of Economy, Trade and Business in Spain. And I belong to the higher corps of Spanish economists and trade experts. Thank you very much.
Thank you so much. Ivo, would you like to go next?
Yeah, no worries. Good morning, good afternoon, everyone. I'm Ivo Nobel. I'm currently the head of the Netherlands Bureau for Investment Screening. I've been active in the field of investment screening for the past 6 years. And before that, similar to Santiago, I've been part of the competition department in the Netherlands for almost 15 years. So I also feel at home at this webinar.
Thank you very much, Ivo. Raphael.
Good afternoon, good morning, everyone. My name is Raphael Mburu. I'm the head of mergers and acquisitions at the Competition Authority of Kenya. Mine is to be grateful to the ICA and Merger Working Group for bringing us together for this webinar and looking forward to having a productive, interactive conversation. Thank you.
Thank you so much. And last but not least, Beatrice.
Good day, everyone. I'm Beatrice Marquez. I serve as a competition expert at the OECD Competition Division. I'm currently working on the intersection of national security and competition enforcement, and we anticipate having a discussion on this front in the Competition Committee in June. And prior to joining the OECD, I served as an Assistant Attorney General at the Office of the New York Attorney General's Antitrust Bureau, where I handled mergers and cartels and monopolization cases across multiple sectors. I'm very delighted to be here, and thank you to the ICN Merger Working Group for the invitation and the moderator and panelists.
Thank you so much, everybody. And I think even from those introductions, we already have some themes emerging because we have, from an institutional point of view, people that have had experience in competition agencies and now are working in agencies that focus primarily on FDI. We have an agency, a competition agency that will be talking about national security issues as well. And we have a multilateral organization, OECD, represented here today. So I think that takes us perhaps to our first bunch of questions and to talk about institutional design and interaction. And let me start and throw out a couple of questions for the speakers to address. So in terms of institutional design and interaction, how do you see FDI screening mechanisms and mergers, by which we really mean competition control regimes, working in your jurisdiction, or in the case of the OECD, across jurisdictions? What policy objectives and substantive issues is your regime designed to address? And what are the key aspects of the timelines and procedures? And can you illustrate your thoughts with any case examples? Let me start with Santiago.
Thank you very much, Rachel. So I'd like to start off by pointing out that both policies, competition policy and FDI screening, are strategic tools of the well-functioning of our single market from the point of view of the European Union. I think our listeners are very much used to what the policy objectives of competition policy are, so I'm not going to touch a lot on that, but I'm just going to highlight the fact that it is true that competition policy, in this case merger review, tries to prevent the formation of market power equilibria so that there are no incentives for firms to harm the market, firms and consumers. So there we have in the first order a market failure, right? And I'd like to think of FDI screening regimes also as another policy response to a market failure, which is externalities. In this case, when we review investments, especially direct investments, the costs and benefits to each transaction are not borne by only the seller and the buyer of that transaction. They are also borne for society. In the current context that we are now navigating, it is of no secret that there are foreign companies, also state-owned actors that pursue different objectives that do not respond to economic rationale, but also diplomatic rationale, politics rationale, or why not say it, military objectives. This is where FDI screen regimes are needed and have been put into place, especially in the European Union after 2019. The policy objective is to protect our internal market, and in that case, protect the free movement of capital, but to guarantee that the foreign capital that enters our market does it aligned with our values and the national security of member states, and in this case, Spain. So there we have two different policy objectives, but key part of our single market. I'd like to touch on the similarities because the policies are very similar in process, methodologies, and timeframes, but it is where we focus more, where our substantive analysis changes. So at least in Spain, in the FDI screening unit, we have learned a lot from the competition authority when it comes to the definition of control. This is a key part for us. And we take up on CNMCs and the law on competition defense rules based on control to establish our own control in foreign investment operations. And timeframes are very much similar, although there are in competition in merger review 2 different phases. Currently in the Spanish FDI screening mechanism, we only have 1 phase. With the approval of a new European regulation, we may be moving into a 2-phase mechanism. So there we may be gaining another similarity. And just to describe very briefly what the FDI screening mechanism in Spain looks like, I'm just going to highlight 2 key aspects. It only looks at foreign investment, and this is important because we only look at investment operations where the ultimate beneficial owner, the UBO, is owned by a firm or a person from outside the European Union. And it has to affect public order, public security, or public health. That's our national security concern there. And that has been translated into 2 possible requirements. Either the investment transaction happens in a sector of our economy that is considered critical, and here we're thinking of critical infrastructure, we're thinking of critical technologies, for example, dual use, or we're thinking of access to sensitive data, media outlets, or essential inputs to the well-functioning of our economy. This is a part where we borrow a lot of expertise from the competition authority, because that's where we analyze how the market operates and the possible players in it. And the other possible requirement is disregarding this economic sector where the investment operation is taking place. You need authorization from the FDI screening authority if the ultimate beneficial owner is controlled by a government or has been sanctioned in the past. So I tried to very briefly describe how the FDI mechanism works in Spain, and I'm going to hand the word back to Rachel. Thank you.
That's a great start, Santiago. Thank you so much. And there's lots to unpack there. Before we start unpacking individual jurisdictions, I think we may find some similarities across jurisdictions. Let's look from a multilateral point of view. And Beatrice, would you like to comment from an OECD multilateral point of view? Speaking in your personal capacity, of course.
Thank you very much, Rachel. So yes, for starters, what we've seen over the past 3 decades across OECD countries is that there's been a significant expansion in the adoption of FDI screening mechanisms across jurisdictions. In 1990, there were only 5 OECD countries that had a FDI screening mechanism. By 2022, we had 24 countries, and by the end of 2024, the vast majority of OECD countries had indeed adopted these mechanisms. And this expansion also reflects a growing emphasis of national security considerations across an increasing number of sectors beyond traditional defense or military applications, which are now regarded as strategic. And Santiago mentioned some of these, such as, for example, technologies or data, but we also see telecommunications network, energy, and health-related industries increasingly falling within the scope of these screening regimes across jurisdictions. At the same time, merger control regimes have remained anchored in competition law. So we're looking at 2 regimes that have increasingly started to apply to the same transactions, but they're grounded in distinct legal mandates. As Santiago mentioned, FDI screenings address risks to national security or essential security, and there's different definitions as to what national security means across jurisdictions and different levels of detail as well as to what that means, while merger enforcement, by contrast, continues to assess competitive effects. And so while the mandates are distinct, it's interesting to note that their effects can interact, where, for example, efficient competition policy and enforcement can ensure that we have an investment-friendly environment that is predictable for investors, and at the same time, foreign investment can itself enhance competition. But now let me turn to a couple of the different regimes that we see across OECD jurisdictions. So in terms of merger control, just at a high level, we see many commonalities, whether it's turnover-based thresholds or notifications for qualifying transactions, phase review procedures, statutory timelines, and judicial review. But for FDI screening, we see this as a little bit more heterogeneous. Notification triggers might depend on sector or ownership thresholds or investor nationality, and the timelines might also vary. And again, the concepts of national security might often be framed in a broader, maybe less defined way. But generally, across jurisdictions, we see three broad models. The most common approach is a parallel or interagency model, where merger control and FDI screening are conducted by distinct statutory frameworks, but and often by different bodies, but with structured participation across agencies. So the US is an example of this, where merger enforcement is conducted by either the DOJ or the FTC, while in terms of foreign investment transactions that might raise national security concerns, these are reviewed by the Committee on Foreign Investment in the United States, CFIUS. And this is an interagency body chaired by the Treasury Department, and DOJ is a member of CFIUS, and it brings its expertise to national security deliberations. However, the antitrust review and the CFIUS review apply different legal standards, and they may proceed concurrently when both are triggered. So clearance under one regime does not determine the outcome under the other. Then Romania illustrates an interagency approach, where its FDI screening mechanism operates through a multi-agency commission called CEFDI. And this is one where the Romanian Competition Council plays a central role, and it's a voting member as part of that commission. So the screening assessment is distinct from merger control, but it does benefit from a competition perspective. And ultimately, the government is the decision maker in terms of the FDI screening. So both systems show an institutional separation, but there is participation across bodies. A different model that is less common today across OECD jurisdictions is where you have a single authority applying both merger control and FDI. This had been a previous case for, say, Poland back in 2020 when it adopted its FDI screening mechanism, where the competition authority conducted both merger control and FDI screening. This has now changed in Poland, where the ministry responsible for FDI screening is the Minister of Economy, but it's an interesting example as to a one-agency approach. And a third approach we see is jurisdictions where there is no FDI screening mechanism, but the competition authority does conduct merger reviews. And we've seen a good example of this, better said, is Chile. And for example, there's been a couple of recent high-profile mergers there with lithium and electricity distribution, where the competition authority was urged to consider national security considerations, but it stated that it was outside of its mandate and it stuck to competition enforcement. Just also to kind of add to what Santiago said, at the regional level, we do see the European Union that is, for example, recently reached political agreement to strengthen and further align its FDI screening framework and enhancing that cooperation among member states. So taken together, there's different regimes, but we do see overlapping review as becoming increasingly common. And of course, this raises some practical questions regarding timing and sequencing and remedies and otherwise. But let me pause here. Thank you.
Thank you so much, Beatrice. And indeed, we'll come on to some of these practical and very important questions. Let me just add one footnote, if I may, to what you said about CFIUS, so that people are not confused. Yes, the Department of Justice conducts the antitrust review and is also a member of CFIUS, but the Department of Justice is actually a number of different components, and it is not the antitrust component that is the member of the CFIUS committee. There's another piece of institutional design there. So we agreed in our pre-discussions as a panel that we wouldn't have every panel member speak on every question, see if we can be self-disciplined, because we thought we then might only get through about 2 questions. So I'm going to suggest to panel members that if you have really would like to add something to a question that you aren't a prime speaker on, feel free to add it when you come and speak on whatever topic you're a prime speaker on. If that's okay with everybody, we don't turn into total chaos here. And on that, if you're in agreement with that, I will move on to the next bunch of questions. And then, as I say, you can wrap your other thoughts into your answers to these subsequent questions. So we've heard how really heterogeneous the institutional design for FDI is, much more so than what we're used to in the competition space. And that obviously takes us on to talking about cooperation and coordination and information sharing with this institutional design structures. So my questions for the next bunch of questions is to ask whether there are any channels for cooperation or coordination between the FDI authorities and the competition agencies in your jurisdiction, whether these are formal or informal channels, and not just between FDI and competition, but also whether there are formal or informal channels of communication between the FDI authority or part of another authority in your jurisdiction and other FDI authorities in other jurisdictions around the world, and how that works. Are there legal constraints, confidentiality rules, your mandates, your review lines, timelines that have an impact on the cooperation, coordination? Have these sought to be addressed in any way? And again, do you have any specific examples? So we are very familiar with this discussion in the competition and competition mergers context, but today we want to broaden it out into the FDI context as well. And to start, if I may, with Rafael.
Thank you, Rachel. And from the discussion so far, I would say Kenya lies in the region where there is no direct legal framework for FDI screening. However, under our Investment Act, parties to an FDI may voluntarily report about the FDI. But that notwithstanding is that between various agencies, we have come up with a way to try and track FDIs. We have what we call a Kenya Investment Authority, and through CanInvest, we are able to create a technical investment committee. And this informal committee normally puts together and tries and checks on FDIs that are happening in the country. And it will bring in various regulators to the table, including certain sectors of the government. For instance, if it's in a mining sector and where you require a mining license from the Ministry of Mining. So you'll find also the State Department for Mining is sitting in that technical investment committee. And what this committee does is that we go through each of the proposed FDIs or people who have come in and trying to make investments in the country. And then we lay out what is of concern to each and each every agency. So for instance, you'll find if someone is trying to make an investment in the banking sector, is that first of all, will it attract the eyes of the Competition Authority? By default, it will go to the Central Bank of Kenya, which is a sector regulator. And in this area is that you find sector regulators play a very critical role. Also, you'd look at it in terms of is the investor also looking at other sectors? For instance, you're doing you're banking, insurance. So also it would also attract the eye of Insurance Regulatory Authority. If also you are in telecommunication, because also you're seeing integrated companies that are coming in, and especially in the banking sector, being heavy on digital platforms. So it also attracts the attention of the Communications Authority. So you'd find that one FDI may cut across various sector regulators. And what we have done through the Technical Investment Committee is that to try and fast track those investments, because you find our country and our economy is heavily dependent on FDI. It counts almost, for the last report I checked from Moncler, it covered around 10% of the GDP. So there's every need to ensure that investment is being done, but in the right framework. And the cooperation has been there. That is one level of cooperation through that Technical Investment Committee, which ultimately reports to the Investment Council, that is now a properly constituted body under the Investment Act. And the chair of the Investment Council is the President of the Republic of Kenya. So you'd find that the technical committee really consolidates all the data that is of what is happening for FDI, and then this goes to the president through the Investment Council. Key also to point out is that in all this process, there's a lot of agency talking to each other. For instance, in banking, in telecommunications, we are being forced to talk to each other so that we ensure that any form of investment that is coming in is well within the law, and we use the least time, because one of the key hindrances in our economy investment is time constraint. You would find, for instance, where you have gotten an approval from one agency, especially like now, for instance, in mining, where you are required to conduct an environmental impact assessment. So before you start your processes, you have already gotten the approval maybe from the mergers and the CAK, but you have not yet gotten your environmental impact assessment completed and approved by the Environmental Management Authority. So one of the things we are trying to do is to ensure that, first of all, is there a flow of the process? For instance, one thing we have put in place is that if, for instance, you're investing in the banking sector, is that central bank would require you to have gotten the approvals from each and every other regulator. Then you go to central bank to ensure that you don't start the process there and then they're telling you have not gotten an approval from Communication Authority, you have not gotten an approval from IRA. Another key area of what would come in is the Data Protection Act, because it plays a very critical role. It's one act that is cutting across, and you find even the global footprint it has, that it comes in very, very handy. So even as you're trying to do the investment, those are things that you'll be made aware that about the Data Protection Act, and what are the policies that you have put in place to ensure that is also flowing. So the Data Protection Commissioner also plays a critical role as you're looking at FDIs that they're happening around. But key to point out is that each of the agencies would conduct their own review of the FDI, and then we will speak to each other to see how best to promote the FDI. I would say the biggest challenge you face with that is, one, there's the timelines that are spent, and also in terms of confidentiality. And at times you may find also there are competing interests, that an agency may feel like this is the work that belongs to us, is not to the other agency. So you find those conflicting interests sometimes may hamper the analysis. But what we have done over time is that, like for instance, for the competition authorities, try to create to have MOUs. For instance, we have an MOU with CA, with IRA, various sector regulators, and also across the region, to ensure that when such a matter is before us, we are able to form a team very quickly to look at it. In terms of national security and a competition authority, I would say one of the areas that is looked at the top level would be at the Technical Investment Committee, where you find even the Ministry of Interior would sit in that committee because of looking at whatever is coming in at that level. Then the second layer, for instance, in the merger regime, you have public interest considerations. And one of the key things we look at is how a transaction is likely to affect a sector, a given sector. So this sector maybe could be any sector that you'd focus on. And the area indicated is that you have, like for instance, areas of health, security, being key areas that other jurisdictions look at in terms of national security. So look at us also looking at how is this transaction likely to impact a certain sector, for instance, health, which would ultimately lead to looking at it in terms of the bigger national interest in that matter. Thank you. Let me stop there for now. Thank you.
That's great, Raphael. Thank you so much. You've touched on so many topics here, interagency within government and so on. Beatrice, you actually foreshadowed some of cooperation in your original remarks. Is there anything you'd like to add? Because I also want to move on back to individual European member states. But feel free to add anything you'd like to.
Thank you, Rachel. So just to echo a couple of the points made by Rafael, generally coordination is bounded by legal and practical constraints beyond institutional design, such as the timelines might differ. Merger regimes typically operate within defined statutory phases, while screening processes may allow for extensions or even call-ins. Then there's the confidentiality point also mentioned by Rafael, where merger control typically contains strict protections for competitively sensitive information. And there's also the issue of third-party submissions, while FDI screening in contracts may involve classified intelligence outputs or sensitive national security assessments. So teams can't necessarily work together or share all of the files given these different constraints. And there's also the issue of different evidentiary standards and mandates, where competition authorities would apply legal and economic tests, screening bodies would apply these broader standards according to how the jurisdiction defines national security. So it will also affect the scope of the information that is requested. Just a kind of related point I'd really like to make is the fact that merger enforcement is a preventative tool. When a decision is made not to prohibit a merger, it doesn't mean that affirmatively a merger is pro-competitive, and the same can be true from a national security context. So it's interesting to think that many transactions might not raise national security concerns, but will raise competition concerns, and the same can be true in the opposite sense. And of course, despite these constraints that we've mentioned, it can be very important to cooperate. This can certainly ensure consistency, and also it's quite important in the context of remedies, especially where they're cumulative remedies. For example, where a competition authority considers structural divestitures or access conditions or vice versa, it'd be important to ensure that these remedies aren't conflicting. And the remedy by a competition authority might also require FDI review in itself if it relates to the transfer of assets to, say, a foreign purchaser. And let me just wrap up very quickly by making a point on international coordination, as you raised this in your question. And I'll just note that, as you mentioned, Rachel, unlike competition law, where there's a long tradition of cooperation across jurisdictions, in the FDI screening context, across OECD jurisdictions at least, we see this as more rare, namely because the interest behind this is to protect national security. But we do see a key exception, which is the European Union under the EU FDI screening regulation, where the member states are certainly cooperating more closely. And outside of the EU framework, we do see a couple of jurisdictions that do actually provide for statutory gateways for information exchange under certain defined circumstances and subject to confidentiality protections. And examples of this are the UK's National Security Investment Act, which allows the Secretary of State to disclose certain information with overseas public authorities, exercising corresponding functions. And there's similar language exceptions within the US Defense Production Act, as amended by FIRMA, where CFIUS can share certain information with allies or partner countries, again, subject to certain confidentiality exceptions. But let me stop there. Thank you.
Thank you so much, Beatrice. So let's move the spotlight specifically to the European Union and EU member states, and bring Ivo, who's been sitting patiently, into the conversation. Just before I ask you some rhetorical questions, Ivo, I just want to notice, no pressure on any of panelists, we're up to almost 100 participants from the audience, which is just fantastic, but also shows the importance and the topicality of this subject. So let's move, Ivo, if you'd like to lead on this, please, on sort of risks of overlaps and fragmentation. We're hearing about the expanding interpretation of national security in many jurisdictions, including EU member states. We're hearing about the importance of national security in the M&A space. We also are all familiar with the European Commission's one-stop shop exclusive jurisdiction over intra-EU transactions under EU merger competition law. But from an FDI screening procedures point of view, how do you see this coming together or not coming together? And do you see, I'm hearing some deal risk and uncertainty and delay risks in the conversation that we've had already to date. Would you like to build on some of those issues?
Yeah, I think, Rachel, thank you for these excellent questions. I think just to reflect quite quickly on topic that I think Beatrice and Rafael mentioned about the design and information sharing. At least in the Netherlands, it's an independent competition authority dealing with merger control, whereas my unit is part of the Ministry of Economic Affairs, and we are directly advising our minister how to deal with cases. So that's one of the institutional difficulties in exchanging information. And as I think Beatrice already mentioned as well, dealing with intelligence and security services and their classified information also puts a hamper on sharing information, even within the borders of one country, let alone within the European Union or on a wider international level. And I think the difference stems from the starting point. As an FDI screening authority, we don't deal with will this deal lead to higher prices, less choice for consumers. We are dealing with supply chains, about the critical infrastructure, about unwanted knowledge transfers. So we're dealing with those types of questions, and in the current world where geopolitical trade and geopolitical partnerships are changing quite quickly, these are different questions and very challenging questions that we try to address. And I think, Rachel, the question that you raised about the one-stop shop from the European Union on merger control versus the national security assessment per member state. There are indeed parallel tracks that we have, but more often as the expansion of what is national security or what assets form part of national security assessments is expanding. I think the potential overlap or conflicts, as you may say, will increase. So it's where previously national security was mostly military or military applications, and as I just mentioned, it has expanded into vital sectors, critical infrastructure, new kind of technologies on semiconductors or quantum technologies. So there are more areas where FDI screening will go parallel with competition enforcement. However, I think the merger control, at least within the European Union, always had this exemption for member states to look at transactions that protect or could harm national interest. I think since the start of the merger control regulation. But I think the ID, what constitutes national security interests, that has expanded over the years. So I think that's something that we'll see more often, and indeed may give rise to further cooperation between merger control and FDI screening. I think in the FDI, at least in the Netherlands, we deal with all kind of transactions. It doesn't matter where the investor is coming from. So we're dealing with inter-EU, so investors coming from outside the EU, entering the Netherlands, but also investors from other European countries as well. But we also screen investment from within the Netherlands. So we don't make a distinction as similar to, I think, merger control about where the investor is coming from. We're looking at the impact of an investment, and I think that's something that may be beneficial. And I think also the current proposed reform of the FDI regulation makes inter-EU transactions screened in more member states, bringing it more in line, I think, with merger control, but also giving more challenges. And I think that is a good transfer to the second question, Rachel, about the potential delay or complexity or increased deal risk that may come from national security assessments. And I think the review timelines, based on my experience as well, at least from the Netherlands perspective, they're quite similar. On the average basis, FDI transactions screened in the Netherlands are handled within 40-50 days. A little bit longer maybe than most merger controls, but not significantly longer. With, of course, more in-depth investigation taking more time, but it is very similar to merger control. And I think it's up to the parties in deal notification that may give rise to lengthening screening times. If you do it sequentially, yes, FDI screening will increase deadlines, but you can also do it separate on a similar timeline, and then I think FDI screening would not lead to a delay. I think there is an increased risk in FDI screening because some of the arguments that we take into consideration are very general or broadly defined in the law. But on a practical level, it's mostly dealt with a classified analysis that's not being made public. So it's from that angle a little bit more difficult for merging parties and their lawyers to fully grasp all the risk. And I think in having a dialogue with the FDI screening authority, you can become quite quickly up to speed on what risk may be associated with a certain transaction. So that could help with the black box that sometimes FDI transactions are. And I think it's good to remind everyone that I think as well in the Netherlands, but also in the EU, and I think it's similar to other jurisdictions as well. Most of the cases are cleared, similar to merger control. I think only 1% roughly are blocked, and I think depending on jurisdiction, and a small number of cases have put in place mitigating measures. And I think that's a topic that will increase as the scope of national security increases, and the concerns about strategic autonomy or open autonomy of certain economies. And there you have to have quick cooperation between not only other FDI screening authorities that are dealing with a case, but also with the competition side, because you don't want to have conflicting mitigating measures put into place, that would be not beneficial to attracting investment. So I think in the end, I think we're not moving towards protectionism. I think that's not the goal of any FDI screening authority. Neither is blocking a merger for every merger control department. But we're moving to more like strategic autonomy discussions. And I think FDI screening is a part in securing investments. But at the same time, our goal is, as is also for merger control, is to be open for investment, because in the end, investment helps the economy to grow. So that's something that we take in consideration always as well. Thank you.
Thank you so much. And you landed just where I was thinking as you were talking. I mean, the Netherlands and the UK, to take two examples, have historically, traditionally been countries that are very open to investment for their economies. Now we have FDI screening processes, but the important point that you made is to ensure that those processes catch the right transactions and don't become so cumbersome that they inhibit investment. That also, the mention of the UK also enables me to put on the record what I realised I forgot when I introduced myself, which shows it's sort of difficult to introduce oneself, which is I forgot to say that I'm here as an MGA to the UK Competition and Markets Authority. And I'm very, very grateful to ICN for the opportunity. So talking about mitigating measures, remedies, outcomes, we've been talking a lot about the start of a process. Now let's look at the end of the process. The risk of divergence, the roles of mitigating measures, remedies in the two different regimes. How does that work? How should it work? Should there be a concern if there are different outcomes or potential for conflict or incompatibility? How can that be addressed when you have regimes that are really, to all intents and purposes, operating for different missions, FDI on the one hand and competition on the other? And how does this work both informally and formally? And as I've asked before, not only between a competition authority and an FDI authority, but also between FDI authorities around the world. Now, we've sort of touched on this a little bit, but I think we want to pull this out and look at it in a bit more detail. Santiago, can we start with you, please?
Yeah, thank you very much, Rachel. So it's actually a great question, and a question that we are still looking for an answer currently. Before tackling it, I would like to touch on some of the points that have been raised by my fellow panelists before, and I want to stress, because they are of extreme relevance, what Ivo just said about being open, but I would add not naive. This is the job of FDI screening authorities, and openness is a policy as a whole of European Union. And I think we are going to keep it that way. And regarding coordination, it is not only about formal coordination channels, which do exist, as Beatriz highlighted before, regarding the European cooperation mechanism, where in this case is Spain, but I think most of the member states are very active and share investment screening operations that affect other jurisdictions. This reflects the complex economic reality and investment transactions that do not only affect one country. So the majority of investment operations we see have different societies and different businesses in different countries. So it is important to talk. And this brings me to the importance of coordination between FDI agencies, which happens not only within the EU forum, but also in forums like this, or in informal forums. We've been talking about the UK, for example. We've had meetings with the UK foreign investment team where we, of course, cannot go into specifics of cases that we are analyzing, but every FDI screening authority is currently facing the same problems. So we're facing problems regarding what constitutes internal restructuring of companies, whether we should look at it through the FDI screening mechanism. And these questions need to be thought not only at the national level, but also at an international level. And forums like this ones and forums regarding exchanges of best practices have worked in the past, and I think will continue to do so in the future. And going into remedies, so first of all, I think we need to be concerned that these risks exist. The fact that competition authority and FDI authority, since they work parallel and they carry out two different substantive tests. That's at least the structure in Spain, where the CNMC is an independent body, and also and then the FDI screening unit belongs to the Ministry of Economy. So we need to be aware that there is a chance where remedies may be incoherent or may be disproportional. So, but on the other hand, the true is that the FDI screening regimes end up with most of the time clearance decisions, and we see a tendency where authorization with remedies is more of a thing. So it's more often nowadays, but still under 10% of the cases. At least that's what the statistics tells us in Spain. And blocking decisions are very rare. We've only blocked 2 decisions. In order to think how it can happen that the remedies may be incoherent, I think it's best to look at specific examples of the worries or sources of concern that we look at in the different cases or policies, as I might say. So, for competition authorities, the concentration of market power is always, or can majority of the cases, viewed as negative. So part of the remedies that are proposed are structural remedies, also because they're easier to follow or to monitor. And we are talking about divestments. They may divest part or the whole of the asset that is being acquired. Whereas in FDI, the source of concern is whether the ultimate beneficial investor of the operation should in itself have access to the technologies that the target has or the information of data that the target has. So if the competition authority decided to sell part of the asset to a third party that may not be, or they may not obtain a clearance decision in FDI screening, that itself could constitute a good incoherence. And the job of public sector would be not to put the investor in a place where they cannot comply with both regimes at once. So in this case, coordination here steps up as another mechanism that needs to be in the first line, where competition authority, when negotiating remedies, needs to be aware that clauses regarding FDI screening need to be added to the remedies being negotiated, or by establishing early warning channels between authorities. Currently, the cooperation and coordination that happens between FDI and competition authorities relies more on informal channels of communications rather than formal channels of communications. And if we decided to move with a more formal channel ways of communication, I think we would catch these potential situations earlier. Although what I said, this has not happened until now. So these risks have not materialized, which means we should not be taking them into account when dealing with both of our regimes. And I just want to conclude by saying that the goal should not be to blur institutional mandates, but to have both authorities be aware that the other authority is looking at the operation and the specific risks that may be addressed. So we may not even need to disclose confidential information or very sensitive information just to have a grasp of the potential risks that are analyzed in specific transactions can help align decisions so we don't become incoherent decisions and put the investor in a place where they have to choose to comply with one regime or the other. Regarding coordination between FDI authorities, the European cooperation mechanism has been very useful for us, and that's our experience, because it provides a safe channel where not only the European Commission but also member states highlight risks that affect them, more than one country as a whole, or maybe risks that we may not have taken into account from a national perspective. So as long as this cooperation mechanism still gives full autonomy to member states to decide on the transaction and serves as a channel to provide information and exchange risks assessments between jurisdictions, is always going to contribute to a richer assessment. And from the point of view of the Spanish authority, we've been participating very actively in this European cooperation mechanism, and in informal channels, not discussing specific cases with fellow allies in the international map. So just to conclude that divergent remedies can happen, but coordination is key to prevent situations from that to happen.
Thank you so much, Santiago. That's very helpful and very open in the approach, rather than pretending there aren't issues to address occasionally. Raphael, from your perspective, particularly from a regional perspective in Africa, do you have some thoughts to add?
Thank you, Rachel. And I think Santiago has really covered it in a very extensive manner. And one thing I'd like to point out is that if you look at FDI specifically on our region, it's really a big government agenda in terms of promoting, both has a political angle to it from the beginning, that you find one of the key deliverables of any government is try to attract investors. So having divergent outcomes from a review would really spur those spanner in the works. Because like you look at, you got different government agencies, and yet you're not able to come to the table and have one direct decision in terms of attracting investment. So you'd find that we really have to work, either whether there's a framework or there's no framework, that government agencies are forced to work together to ensure that the investment is done and within the law, that we don't have divergent outcomes on the same review. You can imagine now, like competition authority saying that a transaction is not, we are barring a transaction from happening. We are declining from approving a merger. And one of the key elements of that merger was that it was to promote employment in the local economy. So you'd find, and government has put employment as a key agenda of its deliverables. So you'd find it may bring a lot of friction at that time. In terms of regional perspective, I would look at it how you find a single country is in different regional economic blocks. Like, for instance, Kenya is in East Africa Community. We are in COMESA. We are in ACFTA. We are in IGAD. All these blocks, and most of them are formed with an economic purpose. You have the common market. You have the East Africa Community, where you have some of the policies that we are looking at investment in terms of one community, one area. So as Kenya, as a country, is trying to push and get investment, you get the predicament also, how fast can you go? What laws can you put in place to attract investment? and yet investment is supposed to happen as one region or one community. Then you have now that fear of, is the country doing this investment first for its own interest, or is it for the interest of the community? And you'd find that various regulatory bodies also exist. For instance, if a country is signing a trade agreement with EU, are they supposed to negotiate as one economic bloc, or each country can go and negotiate on its own? The rules and regulations say that you have to go and negotiate as a bloc. But how fast also are you trying to attract investments to your region? Then once the investor has come into your country, they try to move to the other country in the region. So the fear of now, like the big brother fear comes in, that you brought in the investor, now you're trying to push the investor to the other people. So there's very big need for there to be proper coordination, because there is a selfish national interest in terms of one, security. For instance, you find a country like Kenya, we have already enacted the data protection law. So when a company is coming in or an investor is coming in, it's very easy and straightforward to know these are the regulations I'm supposed to follow. But the same have not been enacted in every COMESA member state or in every member of ACFTA. So when they go to that region, what are they supposed to follow in? Or how are they supposed to look at that? National security. We are aware that we come from a region where national security plays a very critical role, especially for the government. Therefore, every investment will be looked at that element. Things that are dealing with the finance, things that are dealing with the accessibility to internet. How do you now manage that balance, that on one side you're promoting investments, and also the decisions that you're making are looking at it in terms of promoting it both regionally and also within a single member state. I had touched on there being membership on various regional bodies, and I would give the example in terms of mergers, where you find, for instance, right now, recently we have the EAC merger regime coming into place. We have the COMESA merger notification that is happening. And now you also have various national merger notification. ACFTA is at the level of developing a proper competition framework, that policy that will now also guide mergers, and maybe there may be also notification at that level. So you can find those are 4 layers of notification. So as much as we are trying to look at how best can we ensure that there's FDI, are we also creating very many barriers to the same FDI with having 4 levels of notification? And then you'd look at it at a holistic level. Do we have adequate resources? For instance, merger regime is a very extensive process. So is that the best way? We'll say, like now, for instance, we're establishing new FDI agency in a country. Are we establishing an FDI for a region or an economic bloc? And yet the resources that are there are already very limited. So how best can we marry this situation? And I was glad to hear from the beginning in terms of Poland, where you find another government agency is trying also, over time, they first of all put FDI within another government agency, which I feel would also be a very good way forward, where you find, as a starter, where can we place this FDI without us having to move it away on its own, because also of the resources you have, and also trying to prevent that element of you delaying investment because you have so many multi-layer levels of notification. Then also the other key thing I would like to point is that in terms of informal cooperation, because we may focus so much on there being formal cooperation, and you end up putting everything in terms of it's the law, it's what confidentiality, what can I give you? But sometimes you find a simple conversation over the table can easily help a whole investment that was supposed to be done within a region appear simpler and be more easier, because now you understand better what's going on between the different agencies. So it's a whole area where I feel like, on one side, the remedies that you provide should actually help promote investment within the law, but also it requires a lot of cooperation, both within a country and within the regional bodies, and also the self-protectionalism, where I'm saying that this is our cake, this is your cake. No, we have to come to a point where we are agreeing that, look, we are all trying to attract investors, and if an investor is up and running quickly, it also helps promote better public interest issues within the region and within each of the countries. Thank you.
Thank you so much. It's very broad-ranging issues here. Let me come back to Ivo and give you a chance, Ivo, to pick up on and expand on something that you hinted at in your earlier questions when you talked about how the European Commission has an exemption in its one-stop shop legislation for certain public interest issues that went in, as you said, the start of the regulation. It's not entirely clear necessarily what it covers, what it should cover these days, or how the Commission and the Member States work together. I'm talking about Article 21.4 for the aficionados of the EU merger regulation. And I think you have some thoughts on how that provision should perhaps operate in the current complex geopolitical environment. That's not a leading question.
No, not at all. Not at all. Now, I think that on this exemption, I think it's important to prevent what you may call borderline cases, where maybe security concerns are misused for protectionist reasons. So I think it will be very beneficial to everyone to have a very clear borders defined about the usage of such articles. I think that will really help. And I think it goes back about the other topic that I raised about the interplay between competition and FDI screening. And I think threats to economic security, I think in the end, and maybe it's because I'm an investment screening authority, I think are best managed or more effectively managed through a dedicated instrument like FDI screening laws. I think a competition law is excellent at addressing issues about market power and price effects. But I think it's very ill-equipped to manage geopolitical risk that countries currently also need to address. I think competition law, most case law starts from the assumption of a rational economic actor, whereas state-owned entities or companies closely related to state-owned entities have very different motivations for certain transactions. That could be gaining access to certain sensitive data or getting some control about critical technologies. That's very difficult to address to competition law. And I think the other part is that most competition law have some kind of benign mergers or certain thresholds. A small 10% investment in a semiconductor firm by a state-owned entity would not necessarily lead to competition concerns on by most competition authorities, but from an economic security risk, national security risk, that could be a very dangerous transaction. So I think the FDI screening laws, they give they define most of the times clearly what the areas of concern, and that they have the instruments as well to deal with the more geopolitical threats. So, but to prevent these protectionist to misuse of those instruments for protectionist ends, you need to have clear decisions that are truly based on national security concerns. I think that's one of the goals that we as investment screening authorities have to make our decisions purely based on national security interests and not on other more protectionist things.
So transparency is a difficult area for transparency, but transparency, I'm not trying to put words into your mouth, I'm just commenting myself, as far as is possible, is something to be considered. We still have over 100 people online, which is just fantastic. So I just want to pause a second and ask CNMC colleagues whether we should stop. We can't take 100 questions this morning, today, whatever time of day it is where you are, but whether we should just pause a second and see if there are 1 or 2 questions that we would like to entertain from the audience, and then we'll come back to the panel for some final comments.
So, Rachel, thank you. Up to now, there is just one question by Calvin Goldman. He says, over the last 2 years, the US and Canada have included economic security within the ambit of national security considerations for foreign investment reviews under CFIUS and the Investment Canada Act. Do European nations also include economic security? And if so, are there regulatory guidelines?
Okay, so we thank Carl Goldman, our colleague friend Carl Goldman, for the question. I don't know whether, do we have a panel member or members who would feel comfortable to tackle the question, respond to the question?
I can take a first try and answer it.
Thank you, Ivo.
I think the question centers on, is there a difference between economic security and national security? At least that's my grasp of the question. And I think it's with all the geopolitical discussions and the more like open strategic autonomy way of thinking, if ever a boundary between economic security and national security, that boundary has been put down, and I think it's very similar. Having a strong protection about your own economic interest, or to assure about a strategic autonomy, is not being independent of every other country, but being dependent upon countries, but other countries being dependent on yourselves as well, is of vital interest for any nation. So I think there's no boundary anymore, but I think there are also no real guidelines. I think you ask, are there any guidelines? There are not. I think that goes back to my previous remarks about the protectionist use of FDI screening laws. It's up to the authorities to really focus on only using this national security paradigm to analyze transactions and not take into consideration any other more protectionist ideas.
If I may, Rachel.
Do go ahead, yes.
Thank you. Yeah, totally in line with Ivo. Just wanted to highlight the fact that within Europe, the difference lays with the regulatory frameworks that we have. So in the European Union, we have an explicit constraint that if foreign investment screening mechanisms are an exception to free movement of capital based on public order, on public policy concerns. So here the case is what Ivo was saying, is whether economic security concerns are within public order, public policy, and as a broad concept, national security. It is clear that some national security concerns have nothing to do with economic security, but a lot of economic security concerns are directly related nowadays with national security, and those are the waters that we're navigating. So explicitly, I don't recall any member state recognizing economic security as a direct goal of the foreign investment mechanism, but I would say it is part of the analysis. It's a variable of the analysis that we look at.
And ultimately, sorry, I'm coming off my moderator role for a second, see if we agree. Ultimately, in the European context, given single market, free movement of goods, capital, and so on, ultimately that there's a court to step in if member states are seen to have used the provisions for not the purposes that they were intended by the legislators. I think I'm getting a nod for our European colleagues. Good. CNMC colleagues, do we have any other questions, or shall I ask the panel to give their closing comments?
I think you can begin with the concluding comments, because there are no more questions on the chat.
Okay, thank you so much. Well, panel members, I know we could talk for a very long time on all these topics. We will. So in terms of forward-looking, which you've already done in your responses to a lot of questions and thoughts, and shared your thoughts, would you each like to, in a minute or maximum 2 minutes, share any final thoughts you have for today's discussion? And I'm going to start with Beatrice, and then go to the individual jurisdictions.
Thank you, Rachel. In 1 minute. So first, picking
Please.
up on a point made by Ivo, looking ahead, I certainly agree that one of the central challenges at the intersection of national security and competition enforcement is this evolving scope of national security. And just to comment on the previous question, we see economic security being adopted as part of national security beyond just the US and the UK, and in some senses is discussed in the EU by other jurisdictions such as Australia, Japan, and China, and many others. So as these concepts broaden, national security concerns are more likely to intersect more frequently with competition enforcement. Just to give a quick example, let's think about the EU merger guidelines update, which is considering concepts such as resilience and competitiveness. And we have seen in actual practice beforehand national security arguments or remedy design come up in cases. So I very much subscribe to what Santiago said, that the goal should not be to blur the institutional mandates. There is a boundary between national security considerations within competition enforcement. Competition authorities can assess market structure and incentives and supplier concentration and dependency risks through measurable competition parameters. However, where the analysis turns to geopolitical alignment or strategic autonomy in a broader sense, here's where the competition authorities' remit, I would personally argue, generally ends, and the government must decide. Thank you.
Thank you so much, Beatrice. Let's go to Raphael, if I may, next. Given that you have both a national and a regional perspective here, do you have any final thoughts you would like to share, Raphael? Just briefly, please, for 1 minute.
Thank you, Rachel. And to the greater extent is that I feel that we require at this stage, we may try to use the tools that we have currently, because one of the biggest risks you find is that every time there is something that is new, we want to create new laws, new regulations, new institutions. So I feel like we are at an opportunity where we can easily, for instance, if it's a country like Kenya, we can use our public interest guidelines under the merger regime to check on elements of, let's say, economic security, national security, and still advise that all you need is the people who are able to do it. Because the biggest risk you face is that when you try to create a new structure, it all now becomes it's a whole process, and ultimately, by the time it's achieving its goal, the ball has already shifted. So it will not actually even achieve whatever you intended to achieve from the first point. So it would be more critical that we take the tools we have right now and also greater cooperation. And also, like now, the conversation we are having here is that it helps also pick out what are some of the ways you can actually check on these very easily. And then from there, you're able to actually observe that, ensure that FDI is for the intended purpose and everything is happening within the required legal framework. Thank you.
Very, very wise and practical thoughts. Thank you so much. Ivo, your final remarks for today, not forever on this topic, just for today.
Yeah, just for today. I think I would end with whilst I just said that there are important differences between competition law and FDI screening. I think venues like this and then having webinars like this and having this discussion between FDI and merger control are very important because we're dealing with similar concepts. We're dealing with the same transactions. And we need to be aligned and an understanding of developments. I think, just as Raphael mentioned, you want to be on top of what's happening and not being behind it. I think things like webinars like this really help achieve that.
Santiago, the final word from the panelists today.
Great. So very, very brief, because I think my fellow panelists touched on the points that I wanted to highlight. So just going to say that in this current geopolitical context that we are currently navigating, each authority is going to face challenges, different ones, but definitely interrelated. So competition authorities are going to be hearing national security concerns by potentially lawyers or companies in order to defend their transactions, and we in foreign direct investment authorities are going to be trying to assess how far we can stretch the chewing gum related to the concept of national security, economic security, and those challenges are going to be very tough in order for us to really, really stick to our mandate, which is national security, and not fall in a protectionist trap. So clearly interesting times and up to the challenge.
Thank you so much. And so that just remains for me to thank the ICN and specifically and especially colleagues at the CNMC for selecting this topic, an important topic, and putting on the webinar today, and to thank all 4 panelists for really excellent, thoughtful analyses of these challenges in today's world, and also for being so open in your approach to how you were talking today, which is very much appreciated. So thank you very much indeed to everybody.
Thank you.
Thank you, Rachel.
Thank you. Thank you. Bye-bye, everybody.
Thank you very much, all the
Thank you,
speakers.
everyone.
Bye. Thank you.